Come on up.
If I have a special circumstance, I'll let you know, but this ain't.
And
Before this case even gets rolling, you need to understand just how serious this courtroom moment really is. What looks like a routine hearing quickly turns into a high-stakes legal crossroads for Lance Christopher Woodward, a man facing not one, but multiple felony indictments, stacked priors, and life-altering consequences. We're talking about enhanced sentencing, firearm possession as a convicted felon, and a judge who is clearly not in the mood for games. The tension here isn't loud, it's calculated. Every word matters. Every decision carries weight. And when plea deals start getting discussed, you know the clock is ticking. One wrong move, and this defendant could be staring at decades behind bars instead of a fixed sentence. So as you watch this unfold, ask yourself this. When the evidence is strong, the video is clear, and the law is unforgiving, do you gamble on trial, or do you take the deal before it disappears?
released in 2009 in the 252nd District Court of Jefferson County next door here for illegal possession of a controlled substance, second-degree felony. Also, you were convicted in Tyler County District Court on March 12th of 2010 for assault family violence. After those two convictions were final, it is alleged that you committed the offense of illegal possession of a controlled substance and were finally convicted of that in this court in 2016. And so that means that this state jail felony, if all of this was true, the punishment, which would otherwise be up to 2 years in the state jail, is now enhanced or raised to what would be the equivalent of a second-degree felony. So you're looking at no less than 2, no more than 20 years confinement in prison and a fine up to $10,000. Plus, you were ineligible for probation in front of a jury with a felony conviction, and you have more than that. Do you understand what you face there?
Yes, sir.
Okay, good. In 25 CR 116.
This is where the legal pressure quietly becomes overwhelming. What the judge is explaining here isn't just background, it's the math of consequences. Because of prior felony convictions, what would normally be a lower-level offense suddenly escalates into something far more severe. Enhancements change everything. They raise sentencing ranges, eliminate probation options, and strip away leniency. And notice how methodical the judge is. He's making absolutely sure the defendant understands exactly what's at risk. 2 to 20 years. No juri probación. No confusión. This isn't intimidation. This is transparency. And here's the key moment. Once enhancements are in play, prosecutors gain leverage. That's why plea offers start to look very different. So pause for a second. If you were sitting there, hearing your past come back to define your future, would you still roll the dice?
It's the offense that they're using to say he was in possession of a firearm by a felon.
Okay, well, the way it was indicted, it came out fortunate for you. Because it would have otherwise, if they would have used a different conviction, then you would have probably been indicted as an habitual felon because of the sequence. But the way they did it, that sequential conviction out of this court is not used. So even though there are two priors, it's only going to be bumped up one level. So this third-degree felony could be prosecuted. If you're found guilty, you would be sentenced as though it were a second-degree felony. And you were looking at then no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. If they would have used a different one, it would have been an habitual felon status, but they didn't.
And I may elect to do that at some point in time, James, but at this stage, it's
there. Until such time,
yes,
we just worked with what we got. And
in light of him rejecting a 10-year offer, I will likely change it.
Well, let's get to this.
Yes, sir.
All right. What's the plan?
Well, the offer was 10 years, as Mr. Ham stated. But my client, he maintains his innocence.
Which he's allowed to do.
right?
Yes, sir.
I mean, I'm asking.
Yes,
You
sir.
understand what you're looking at?
There's a clear video where we see him in possession of the gun and placing it beside, trying to prevent the officers from seeing it. He's on a stolen ATV with an ignition that's been modified. It doesn't even have a key. It's hot wired.
You know that. Y'all.
I'm stating all that because I'm guessing he hasn't seen the video.
All right. Well, anyway, this is the day where you make a choice. And,
I'll take the.
That's, we're moving forward. They say they're going to re-indict.
Yeah, I mean, if he's going to turn down 10 years, I'm going to leave him exposed to 25 to life.
And it's his free will.
Yes,
He
sir.
can make a choice.
And you should do that, sir.
And here it is, the moment where reality hits. The tone changes. The courtroom energy shifts. Just seconds earlier, the defendant is standing firm, rejecting the offer. But now, faced with video evidence, a stolen ATV, a firearm on camera, and a looming threat of re-indictment as a habitual felon, suddenly that confidence cracks. This is a classic courtroom pivot. Prosecutors apply pressure. The judge lays out exposure. And defense counsel knows when the risk outweighs the pride. 10 years may sound harsh, but compared to 5 to life, it's survival mode. This is why plea deals exist. Not because defendants are innocent or guilty by default, but because the uncertainty of trial can be devastating. So ask yourself, was this a smart legal decision or a forced surrender?
That bell around his neck.
Right.
Quite a few people that.
Ready?
Yes, sir.
25 CR 1160 is now called. The state of Texas versus Lance Christopher Woodward. Mr. Woodward is present with his attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
We're only going on paragraph 1.
Yes, sir.
In summary, sir, this indictment alleges that on or about July 3rd, 2025, in Jefferson County, Texas, you committed the third-degree felony of unlawful possession of a firearm by previously being a convicted felon on May 18th, 2016, out of this criminal district court for the felony offense of being convicted of illegal possession of a controlled substance. Do you understand what you're charged with, sir, with this? Stand by. Y'all got this wrong. This is showing it's a third degree felony. Y'all showing it as a second.
You can proceed on count 1, Judge, and that'll be fine. Since he's taking 10, we can proceed on count 1.
This is a third degree felony, sir, which means you face at no less than 2, no more than 10 years confinement in prison and a fine up to $10,000 if convicted of this. Do you understand? Yes.
Yes, sir.
An agreement has been reached where you would be pleading guilty, sentenced to 10 years in prison. And then cause number 1159, that pending indictment will be dismissed as part of this agreement. Is that your understanding of the plan?
Yes. I'll just miss the other.
If I follow this agreement, you have no right of appeal of your case, which I intend to do. Do you understand? You have no right of appeal.
No right to sue.
How do you plead to this charge, sir? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty of what this alleges in this third degree felony of unlawful possession of a firearm by a previous conviction of a felon? I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
State's Exhibit 1.
No
Made
objection.
a part of the record without objection. Oh, pre-sentence report is waived here.
Yes, sir.
I will follow this agreement. If
Thank
nothing
you,
further
Judge.
to add and find you are mentally competent to enter your guilty plea, sir. It is freely and voluntarily made. You know and understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this third-degree felony of unlawful possession of a firearm by a felon. I am finding you guilty beyond a reasonable doubt of this offense. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. And you'll be given credit for all time served in accordance with this case. As part of this agreement, cause number 1159 will be dismissed. Do you understand what has happened today, sir?
Yes, sir. I got 10 years.
And a case got dismissed. Another one got dismissed. That should take care of everything. I don't think we have.
At the end of the day, this courtroom delivered a clear outcome. Lance Christopher Woodward pleaded guilty to unlawful possession of a firearm by a felon and received a 10-year prison sentence, with the second case dismissed as part of the agreement. The judge ensured the plea was knowing, voluntary, and supported by evidence, locking in a legally sound resolution. No appeal, no trial, just finality. This case is a textbook example of how prior convictions amplify consequences and how fast a defendant's options can disappear once evidence and enhancement collide. The law doesn't forget, and neither does the record. Back into next pointing right now. I want to hear from you. Was taking the 10-year deal the right move, or should he have fought in court? If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns you won't see anywhere else.